From a man trying to run over his girlfriend in a fit of rage,
after which the defendant chased the victim with his car and almost ran her over,
to a tenant stubbornly refusing to vacate a property despite clear eviction orders.
I need more time than 30 days to get out of there. It's not like I don't want to go to trial. I really don't. I want to be done with it.
These cases showcase how Judge Simpson tolerates no nonsense from criminals, ensuring accountability. Starting with Mr. Glover, who recklessly tried to run over his girlfriend in a fit of rage, it's shocking how he didn't stop there but continued to threaten and intimidate her, showing absolutely no remorse for his actions.
Morning. Your name? Deshaun Glover. All right. What are we doing today?
Your Honor, I am going to ask for another PCC. I know I didn't fill out this.
He didn't fill out the probable cause conference will be adjourned December 5th, 2024, 9 a.m. Yes, Esteban.
Yeah, Your Honor, Esteban, Your Honor, I spoke with his mom. They have retained counsel. Obviously, the requirements. He's not going to be a flight risk, Your Honor. This is my client works with his uncle. I can verify the company. He does landscaping. They're doing snow removal right now. And we're asking for a lower bond, Your Honor. If we can even do house arrest, that's fine for right now for my client.
Response from the people.
one out of Taylor for $400, one out of Flint for $3,000, and one out of Genesee for $500. He has 2 prior convictions for fleeing third, one from 2010, one from 2015, a prior conviction for R&O. Beyond that, the nature of this case is concerning in and of itself. The charging ETA on this actually requested a $500,000 cash security for $150,000. In this particular case, the defendant went to the Comfort Inn to have sex with the victim. The defendant and the victim got into an argument, after which the defendant chased the victim with his car and almost ran her over. Law enforcement arrived on scene and observed the defendant's vehicle and observed the victim exit the vehicle and enter the hotel. On contact with law enforcement, the defendant admitted to chasing the victim in the parking lot, but denied hitting her. When the law enforcement contacted the victim, she was visibly distraught and expressed fear of speaking out against the defendant because of potential retaliation. The victim advised that she previously tried to leave the defendant, but he wrecked his car, and when she tried to get her own apartment, the defendant showed up with a baseball bat and began breaking things. And then after he was breaking things, he said, "Are you still leaving?" The victim also advised that the defendant has quote unquote people who will hurt her if she speaks out against the defendant. I mean, at this point, I'm significantly concerned. I think on to lower than we originally asked for. I understand it's high, but I don't think reduction is appropriate.
This man's audacity level is outrageous. I mean, what explains him causing so much pain and then turning around to expect lesser punishment? He probably feels untouchable or above the law.
Your Honor, as an officer of the court, I think the victim,
Pardon?
she has called me 2-3 times, and they were in a relationship, dating relationship, Your Honor. So that was his girlfriend, and it still is his girlfriend. So I'm not exactly sure what the nature of the victim and what the sister counsel is referring to, but that is my client's girlfriend. They've been in a relationship for a couple of years, Your Honor, and she has called me as recently as today, as to try to advocate for my client.
Given the statements that she made to law enforcement, it's pretty clear potentially why she would be motivated to do that if she has concerns about retaliation, if she were to participate or do anything other than advocate.
And Your Honor, if I may, we can ask.
Yeah, go ahead.
I want to put in quotation marks, victim. She was willing to come to court today. I just advised not to, just as a ear of impropriety, but she can appear in court, and obviously she can tell you freely what her intentions and fear of repercussions are in person.
Come on, make it make sense. It's obvious she's scared he would hurt her more if she doesn't cooperate.
Well, I guess I hear what you're saying, counsel, but I guess it could happen. I'm trying to reconcile count 2 as charged with the statement of the relationship of the parties.
And how long have you been dating?
For nearly 2 years now, sir.
Okay, but I guess what I'm getting at is that charge count 2 is the transportation of a person across state lines to assist in prostitution. And that individual named it.
Yeah, Your Honor, and we are miffed with that.
Pardon?
That we're confused why that was charged, and for the nature, it has nothing to do with any of the police report had anything to do with prostitution or anything like that. Even the victim herself didn't state that she was there to do that. We were just confused and surprised, Your Honor, by that. And obviously talking with her, that she's mentioned to me several times with her talking with her mom, his mom. She's called me several times. I said this morning, and took his car when the incident happened, drove it back to Flint, Your Honor. So this is not what that police report alleges.
Well, okay, then I'm gonna need some further clarification
Okay.
on that before I do anything
Sure.
regarding bond on this. So at this juncture, I'm gonna deny the request for,
And I'll have her in 2 weeks, Your Honor, have her here. Thank you.
thank you.
While Mr. Glover faced charges of assaulting his girlfriend, here we have a crazier case. Mr. Wade is facing charges of masturbating in front of a female correctional officer while in custody.
Your Honor, Hannah Mackey appearing on behalf of Mr. Wade, who is appearing to my right. Mr. Wade, please state your name for the record.
Beyond Wade.
All right, he's waiving exam.
Yes, Your Honor.
Defendant every way formal reading standing mute, court will enter not guilty plea. Pretrial will be set before December 3rd, 2024, 1:30.
Thank you. Your Honor, may I quickly address bond?
Why not? Everybody else says yes.
Pardon?
Yes.
Oh, thank you. Your Honor, in this case, bond is set for $10,000 with 10% bond for which Mr. Wade can't afford. The client does advise that he has a bed at Delana Center and he is willing to do a GPS tether. He's not intending on going anywhere as he had just started his probation and he is seeking employment. On this matter, probation has given him 2 PR bonds on the circuit court matters, which should speak to their assessment of flight risk and danger.
So why is he locked up then? There anything unfair as to my questions? Why is he locked up on this case? If he has PRs on the circuit court matters, why is he in custody?
Your Honor, I believe that there was a violation incident because of these charges in the circuit court. They let him out on PR. As a result of this pending matter, we're asking for his release on this case as a result of that. And he got probation violations as a result of this charge, Your Honor. Circuit court gave him PRs on their matters.
On the violations?
On the violation.
Is that the people's understanding?
I don't know, I'm trying to get through his 26-page criminal history, but if I'm understanding correctly, he told him $1,000 on this, he asked just for an in-custody date, so we can get all the matters before Judge Kunke, and I don't think a PR bond is appropriate. The allegations in this case are that the defendant was masturbating in front of a female correctional officer, so if he's certainly willing to do that in custody, I do believe that he could be a danger to the community if he's out of custody. And if he doesn't have anywhere to live, I don't know.
Your Honor, he has a bed at Delana Center, if I may. And he is willing to do GPS tether.
Well, he has a bed there?
Yes.
Well, I understand that, but
Mr. Wade has no interest in reform. It's outrageous how he chose to continue with disrespect and abuse toward others. Leaving him out on PR bond doesn't even make sense.
So why was he in custody
Before this
to
happened.
even be able to commit this offense?
Is it my understanding, Mr. Word, that you were waiting on getting a PSI done?
This case is from February when I was locked up.
And you were locked up in February because of the cases that are before the circuit court now?
That's because of the cases that was PR bond to me.
Because what?
Because of the cases that was
Yes.
PR bond.
The circuit court matters, Your Honor.
So these offenses he committed while on
While I was in
bond, but while he was incarcerated on another case.
and they didn't charge me with it until I just recently
Thank
got locked up.
And Your Honor, he was arraigned on October 28th before Judge Slay. He had the hearing before Judge Kunke, who then gave him a PR, and that was on the date of 10/31. So he's had a PR on those matters.
Well, I'll tell you what, he's gonna be up before. I don't think it's appropriate to let him out on a PR given the circumstances, but I'm sure Judge Kunke may feel differently having given him PR on the probation violation. So I'm gonna deny the request at this time, and you can take it up with Judge Kunke.
Okay.
Bond
Your
will
Honor.
continue.
Unlike Mr. Wade's case, Judge Simpson now faces a chaotic situation. Here, Mr. Isom blatantly violated a no-contact order by sitting next to his victim in court just a week after it was issued. Meanwhile, his wife is asking the court to lift the order, saying she depends on him.
Herbert L. Isom.
Thank you, sir. Your Honor, today is the date and time set for pretrial. We are asking for an adjourned pretrial date. We understand that December 16th.
Yes, as to bond.
This is a domestic violence case. In this case, the victim of the domestic violence incident was present in the courtroom. She informed me that the defendant sat down next to her in the courtroom when he came in. They were sitting together. My victim advocate did see that. They were separated when Mr. Lindell took the defendant out and hoping to speak to them. And at that time, I know the victim advocate went and spoke with the victim. For the record, this is not a crowded courtroom. There are many, many open seats available. There is a no contact order that was entered on November 25th, 2024. It's now December 2nd, so just a few days ago, where the defendant wants to have absolutely no contact with the victim. People would contend that sitting next to her is contact. I understand that she is here to address the court to request a removal of the no contact order. I have other information about that to share with the court whenever the court's ready, but she hasn't made that request yet, so it may be premature for me to respond to it. But I'm very concerned by him sitting down next to her when he's supposed to have absolutely no contact with her.
Response.
Yes, Your Honor. It is true. I spoke with Mr. Isom and as well as the complainant this morning. It is my understanding that we will be making a request to lift the no contact order and the no go-to order. Mr. Isom tells me that he has had no other contact. He has been abiding by the no contact order except for in the court this morning. And it's my understanding that.
Where does he reside?
Where you live at the moment?
My brother's.
And Your Honor, we are requesting that the no contact order be converted to a no non-consensual contact order, as well as a no go-to order be lifted. It's my understanding that the complainant needs help around the house with both for herself as well as for their 4 dogs. And so we are just requesting that I did talk to my client about what the no contact order means, and that at the meantime, he should not be having contact until the court agrees. After we spoke, I instructed him to separate himself and sit on the other side of the courtroom, which he had no issue doing. So no matter what the court orders today, I'm confident that Mr. Isom will abide by whatever the order is, but we are requesting that.
Well, did he understand there was a no contact order in place?
Yes, I understood it, but I didn't know that in the court, that would be the same thing. I thought with the people here that.
Why would it change?
I'm stupid.
Sir, the best I can explain this to you, I take the no contact orders very seriously. And when the court says no contact, that means no contact.
I understand.
Ms. Lundy, you wanted to say something else?
Your Honor, I just will let the court know as well. I heard the defendant say a second ago that he was staying off of Michigan. I would note for the record that the address shared with the victim was also off of Michigan Ave. So I hope that he is being truthful when he says that that's also where his brother is. We did request a $25,000 surety bond. He was given a $5,000 PR bond. No electronic monitoring. I know the court historically has liked to hear from the victim, and if the court intends to follow that procedure, I'm happy to place my concerns about that on the record after we hear from her, or I can do it now. Whatever.
No, I can hear from you afterwards.
Okay.
Okay, where is she? Come on, sir, have a seat over here. Hello.
Good afternoon, Your Honor. My name is Donna Dennison, and I truly understand about the no contact, and I truly apologize. When he came into the court, I just scooted over so he could sit next to me. I didn't, like he said, ignorance. And I understand and I respect the court, and I duly greatly apologize. But me and the babies, we do need him to come home. He is our only care provider who takes me to my doctor's appointments.
And I'll let you go on and tell me everything you want, but let me just tell you this.
I'm so sorry, Your Honor.
No, but ma'am, understand it's not your responsibility. It's his responsibility. All right, you could have scooted it over and give him all kinds of room. It wouldn't matter. He understands or should understand what the court's order is. Anything else you want to tell me?
I would just please ask the court if they could let him please come home. We truly need him there.
All right. Thank you.
Thank you, Your Honor.
Every move of Mr. Isom screams manipulation, not remorse. He knows what he's doing. I wouldn't fall for that fake apology he just made to make this worse. It's annoying watching her plead for someone who's hurt her so deeply.
Governor, in late 2023, the defendant was charged with domestic violence by my office, naming Ms. Nelson's victim at that time. I believe he was arraigned on December 26, 2023, and given a contact order. And pretrial hearing before this court, Your Honor, on January 8, 2024, Ms. Dennison appeared, requested the no contact order be lifted. That case was ultimately dismissed at the time of the final settlement conference in February of 2024. And we're back here again, new allegations of domestic violence. I'm very concerned for the victim's safety. I'm concerned that the obligation of the no contact order feels on her. Obviously, we can't control how she feels and how she thinks, but the court is familiar with domestic violence situations, domestic violence relationships, and the shifting of responsibility that went on. So I'm asking the court maintain the no contact order.
No, I was anticipating what the court was going to. I thought I was anticipating what the court was going to ask. I just would add that the allegation in the police report is that this is a single shove onto a couch. Is the allegation of the domestic violence. So the underlying crime that is alleged is fairly minor as far as in terms of the range of domestic violence cases that this court sees. And so I think that should be a consideration as well.
Well, but counsel, there's also an allegation of destruction of her property, right? So it's that being the count 2 on the complaint. So it's not maybe as simplistic as one wants. Yeah, well, I'm concerned about a number of things. I'm concerned about the fact that we had the previous case. I'm also concerned that there's a no contact order in place, and it's just just ignore it. Doesn't work that way. I mean, the cold-hearted reality is maybe you ought to tell me why I shouldn't incarcerate the defendant. I don't know that I could trust him.
Your Honor, I mean, I think, given the nature of the contact and the fact that the complainant is here requesting, she came here specifically to request that the no contact order be lifted. I understand, Your Honor, it is what it is. We are the court, prosecutor, court staff witnessed what they saw. However, incarceration, I feel, does not suit the alleged crime. I feel it's, I can understand the court perhaps denying the motion, but incarceration at this time does not seems
yeah, but if somebody's not listening to the court, why would I just slap them on the hand and tell them to go forth and sin no more? I mean, this isn't a hard one to understand.
No, certainly not, Your Honor. I suppose we are asking for clemency at this time.
I did get into the meat and potatoes of the report, but for the court's information, the officers observed that the bed mattress was flipped over in the bedroom.
Say that part to me again.
So the report reads that there was broken glass came from old Christmas ornaments that Dennison had destroyed. I think that may be a typo and may need to say item. I think that just may be a typo, but that is what the report reads. And I want to be candid to the court.
In that last case, one of the other issues here is, and Mr. Burdell, maybe you can explain to me, why would your client be under a different assumption of what no contact meant if he's been through this before? I mean, it almost points to a flagrant violation because he's been through the process before. Go ahead.
No, Judge, I believe, I think Mr. Isom has explained himself, and at this time I have nothing to add on as to what his motivation, what was inside his mind at the time.
On the last case, did he abide by the no contact on the last case, or did we have problems?
So I wasn't involved in the last case, but Mr. Isom is assuring me that he did on the last case. That he was never violated on the last case, which again was dismissed. It's not a case he was not convicted for. It was not the case he was convicted of.
I understand that. I guess I'm trying to figure out whether or not, because the issue for me is whether or not he's going to follow the court's order.
Well, Your Honor, I have my limited contact with Mr. Isom in our conversations. I am confident that he will abide by the orders. He is, he has assured me that there have been no contact prior to this, and he has abided by the no contact order. Outside of the court, there've been no calls, there's been no contact. He immediately moved in with his brother. He's 60 years old and then with his brother into an apartment, Judge. And I am confident, no matter what the court orders today, he will abide by the no contact order. Granted, this is a fairly new case. However, he has been, other than the indiscretion this morning, he has been compliant with the court's orders on everything.
Is he working?
He does, he's remodeling as a contractor. Are you a self-employed or do you work for somebody? He's self-employed.
So, sir, your release order indicates, reading from paragraph 10, you're not to go, I'll leave out the lot number, except with a civil standby with the police. Then it further reads, if this is your home address, which it is, you must find another place to live and notify court of your new address within 24 hours of your release from jail by contacting, and then we put the court's number in. What?
Just for the.
I understand it's the first pretrial, but I mean, I've got at least 2 violations before we've had the first pretrial. I mean, what is it? He doesn't think he has to follow the rule?
No, Judge, that's certainly not it. I mean, this is, understand with the holidays that just occurred. It is a lot going on for a civilian. So, but I've assured him now that he has counsel. Like I said, I was just very recently appointed. I will make sure to give him extra attention to guide him to make sure that he is in compliance going forward.
And when did you go to your brother's? And so on the 26th and 27th, you didn't think you had to notify the court?
I didn't understand that part.
This man has no respect for the court or its orders, and it's obvious Judge Simpson isn't going to tolerate his blatant defiance. It's crazy how he thinks he can outsmart the judge, manipulate the system, and get away with it.
He knows what the rules are. He knows what's supposed to happen. He was apprised in his previous case, he would have been apprised by the magistrate of the no contact. In this case, he's also apprised by the magistrate of the no contact. I think what makes this even a little bit more disturbing, and what I had indicated to counsel, was the notes from the magistrate signaled the court that at the time of your arraignment, there was particular mention that the parties had been residing together since the incident, and that was made known to the court because of the intervening time frame. However, what that tells me is that it was more emphasized that there was a no contact, because I can tell that because the magistrate wrote it in her writing in the file that that's specifically what she's ordering. So that I'm clear in that regard, there was going to be this significant change in what was happening. It wasn't like something happened and then you're arraigned and going to do that. That was brought up. That's outside of the fact that then defendant is specifically told he cannot have contact. Specifically told that. And so the fact that he's been through it, the fact that that was raised at exam, he then comes in here and completely goes the opposite way and then sits down there. I can't ignore that. I think the other thing that is a bit troubling for the court, and part of the reason we tell you, you have to give us a new address, is to make sure that you're where you're supposed to be, or more specifically, not someplace you're not supposed to be. We don't have that either from me. So what I'm going to do here is that the defendant will be placed upon a GPS tether upon release. I'm not going to make it home confinement, but I am going to sentence him to jail. I'm going to sentence you to 5 days in the Washington County Jail for the violations. On your release, you'll be released on a PR with a GPS tether prior to release. Defendant is remanded.
Is the court denying the request to change the no contact to a no non-consensual contact?
I am also denying that request.
You know the saying, once an abuser, always an abuser? Here we have Mr. Glover, who refuses to stop his threats and intimidation, even while in custody.
Good morning, Your Honor, and your staff, Attorney Quentin Dox. My P number is 79657. On behalf of my client, Deshaun Glover.
Your name, sir?
Deshaun Glover.
Thank you. All right, what are we doing?
Your Honor, we're going to ask for a preliminary exam at the earliest convenience.
I don't think that that's appropriate at this time. Defense counsel asked me this morning to get media discovery because he only has paper. I informed him of the proper procedure on how to get discovery from our office, but he is not in receipt of that yet. So I don't think it's appropriate to set today.
So all discovery is not complete.
I have the
Correct.
paper, Your Honor. The digital, I do not have.
You do not have the, okay. Go ahead, sir. What do you want to tell me?
Sir, I just wanted to say I've been in jail for 60 days because we've been trying to receive a discovery. And it's like the more you're journeying and push it
What do
back,
you mean you've been trying to receive it?
like I
Mr. Glover, hold on for a second. Just let the judge do his process first, then we can talk.
What I was going to do is I was just going to adjourn it out 1 week so that all of the information is there. I don't know what.
Your Honor, before we set a date, I do think potentially I should address a bond issue first.
Okay. All right. So I'm going to adjourn it, but I'll let you go ahead. What do you want to tell me?
Your Honor, the defendant has called the victim over 300 times. At this point, he has made comments and had conversations with the victim, including things like instructing her to come to court and not let anybody but the defense attorney know that she's there. And he said, they don't have a good phone number for you for nothing, so you don't even need to bring a phone. Just be there in the crowd of the courtroom and let my lawyer know you're there. This lines up with the fact that Mr. Dox has informed me that the victim was going to be present in order to address the court to say that the allegations are false. At this point, I am very concerned about the nature of these calls. Given that there's 300, I haven't had a chance, over 300, I had a chance to listen to them all. My interns haven't, but there seems to be serious grounds for forfeiture here. So I think in order to ensure that Mr. Glover has due process, as well as that we're proceeding in a allowed to do our due diligence, we need a bit more time.
Okay. And so outside of the other discovery, that information is also going to be provided to defense counsel, the phone
Yes,
calls.
and that is not going to be able to be sent today because it's my understanding he's used over 8 other inmate pins to make these calls. So it's not a matter of me just sending one email to Miss Doherty at the jail to have them all released. I have to go in and download them each individually and then manually send them over to Mr. Dox.
The audacity level here is crazy. If this man can manipulate and intimidate from behind bars, imagine the harm he's capable of causing if given the chance.
All right. Counsel, you have anything to say regarding that? Sure.
Your Honor, I believe that the complaining witness in this case, as I alluded 2 weeks before, has been trying to call my client, Your Honor. She is there not to, on her own volition, Your Honor, just to say to the court, not to talk about the case, but that she is not afraid of my client, Your Honor, that she has not been threatened by my client, and that she would like the no contact order to be released. That is to my understanding. And she is in the courtroom right now.
I think that's my concern too.
You think she's here now?
Yes, Your Honor.
There, Kaylee Loveday?
Yeah.
Okay. So normally, and ma'am, is it correct that you're coming down to ask me to lift the no contact?
Yeah.
All right. So here's the way I'm going to handle it, because normally what I would do is I would hear from her, be assured myself that it would be proper to do so. The problem now that I have in this case is that the people have indicated these 300 calls in which the defendant is not to be having contact with her at all whatsoever. But these 300 calls lead the court and counsel, and the prosecutor's been frank, she can't get through them all, but it's leading the court to believe that there's some manipulation by the defendant regarding this particular criminal proceeding. And so, ma'am, with all due respect, you may or may not be involved in it. I'm not making a determination at this point in time. I'm not going to hear from you today. I'm not changing any of the bond conditions. I'm not changing the bond conditions regarding contact. I am revoking in its entirety the defendant's phone privileges except for communication to counsel. So he should not be talking to anybody from the jail unless it is his attorney. And I've signed that order already. So I'm changing that. The other issue that comes up is she's here today, but I don't know what was said. And by the time we get to preliminary examination, if she's not here, the people rightfully could then proceed by forfeiture. They could also do so, and there may be issues regarding any testimony that she might give if it is inconsistent with other testimony. I'm not going to go through all of that. I will just say this. Sarah, I appreciate what you're saying in terms of discovery, but it seems to me some of the discovery you're creating yourself, and that has to get over the counsel. So that delay is you.
Yes, sir.
So here's what I'm going to do.
Or no?
Yeah, I'll let you talk to me.
No,
But
Mr. Glover.
You're probably
No,
talking
Mr. Glover.
too much.
Yeah, no, Mr. Glover. Go ahead, Your Honor.
All right. So probable cause conference, dear goodness. That the one part of the discovery is going to get to counsel probably today. How long, and I'm not going to hold you to the exact thing, but how long will it take to get the phone calls to him, you think?
I will do my best to get it to him in 2 weeks. I don't think that I'm not gonna be able to listen to them in 2 weeks' time. I can say that for certain. I'm not sure that I need to listen to them all, but I think assuredly I can get them to him in 2 weeks.
Got it. Okay. So given all of that, then I'm going to set
Full trust in Judge Simpson. He's not buying these excuses or stories without solid evidence to back them up.
comes out in 2 weeks.
Your Honor, can I?
Counsel, would you?
No, Mr. Glover.
Yeah.
One more time. You'll have a chance.
I just don't want to go to court. I just don't want to be pushed back so far. I'm trying to.
You know what? I don't want it to either.
Yes, sir.
But you've also got an attorney that's got to do his job. Your behavior, if true, is making it infinitely more difficult for him to do that.
Yes, sir.
If you stop doing what you're doing, there is not a doubt in my mind that your attorney would be ready to go.
Yes, sir.
So don't be complaining that you don't want anything pushed back. Don't be complaining about any of that. Stop doing what you're doing. Counsel, if those come out in 2 weeks, so just so that they at least get to you and you can look at them, and then we can certainly go from there. Then the next date I have for a probable cause conference after that is the 26th. Are you available?
Yes, Your Honor.
Day after Christmas? Would you be able to do that, sir?
Yes, sir. I'll be via Zoom, but I'll be out of town, but I can do it. Yes.
Okay.
Finally, this case here centers on Ms. Garden, who refuses to move out despite the landlord making it clear she needs to leave. It's crazy how she's blaming everything from unsafe conditions to unfinished repairs, even after the court ordered her to vacate.
So, Your Honor, I filed a motion to dismiss. I'm not sure if that came into your chambers yet.
What's the basis of your motion to dismiss?
The fact that the water bill is what I'm being charged for as non-payment of rent. The water bill is high due to a broken wax ring in the toilet. As per a contractor that Ms. Jelani hired, who stated that this is the cause of the entire problem, and that's never been fixed. That was the first time when the ceiling collapsed, they figured this would happen. So a year later, this was not professionally done. She dismissed this contractor because she didn't want to get it done right. She hired a family friend who did not fix it right. She did not replace the tub or the toilet or fix the wax ring. So because of that, as per his expertise, he stated that
How much is owing?
I'm sorry?
Your Honor, if I may, these two cases were consolidated. There was originally a non-payment case, and then there is a termination of tenancy case as well. Quite frankly, we're just looking for possession back, and I'd be more than happy to dismiss the non-payment of rent.
And there's no lease,
The lease expired in May.
so there's no lease.
We're at a month to month and I want to leave. I can't leave because work is being done.
Says what?
The work is being done in the home and there's mold in the home. I put that all in the case that
I understand that, ma'am, but what they want is for you to vacate the premises. And so you're telling me you can't leave because why?
because there's mold in the home and it's not safe to go in. There's no movers who will go in there. I don't mind, I don't want to stay there, but I can't get my stuff out because when we left, everything was just as it was. And it's been that way since August till today. So till today, work is not being done. If you go in there, from what a mover I did send over there saw, it's the floors are missing. They're like, they're not going there. It's not safe. And I can definitely do that as long as it's safe to go in for someone. I'm not gonna get sued for.
Well, who said it's unsafe?
A couple of things. There's a sticker on the doors.
What sticker?
There's a sticker.
If I may, Your Honor.
There's a sticker on the door by the fire chief. Do not enter the property unless you're working on it.
Correct.
Right.
Which means that you can enter the premises.
Right. They can enter the premises to do work or to move, but companies are not willing to go in like that. I had one company call before.
When are you gonna get your stuff out?
As soon as they're done working on the property. Or as
No,
soon as it's safe
it
enough.
doesn't work that way.
Okay,
You've got to get your property out.
absolutely, but no one will go in there and take it out because of the status of the home.
Who,
I have repeatedly requested just a date or a time frame to get stuff out, and I'm still not done.
When there's floors, then people can go in and take stuff out. There's no floors to walk on. And there's
how
mold.
much property's in there?
A lot, my whole house, my whole life, Your Honor.
So what would you do if I said they can move it out, put it outside the premises, you gotta come get it?
That wouldn't be fair. 'Cause
Pardon, that what?
It wouldn't be fair because.
It wouldn't be?
My whole life is in there, Your Honor. I have to pack my stuff, my children's stuff. People just coming in and just taking your stuff out.
But you can't just sit there and not do anything.
I'm not, sir. I'm looking for someone who is willing to go in there and remove my items.
Then what you need to do
Okay.
is I'll pass it, take a break. You need to call. I want to know who you called. Find somebody before you leave here today.
So I have to have my stuff out by today.
What did I just say to you?
He said, find somebody.
You need to call somebody. You can use your phone, look up whoever you got to look up.
Okay.
Call them, find somebody that's going to move your stuff and when they can do it.
Okay, thank you. All right, thank you.
And then I'll call the case back up, but don't leave the building until such time as.
Now that's called not tolerating weak excuses. It's pathetic how she thinks she can just occupy a free storage space.
Go ahead.
So I called several companies and they posed a very valid question that I forgot to bring up. Where will you be taking your items to now? I don't have any place to take it because I'm displaced because of the landlord's negligence to fix the housing, the ceiling collapse. So I'm in a hotel with 4 children. I have nowhere to take it. That's one thing. I need time to find a place. I've been looking since May and even more now in August, and nobody wants to rent with me because they're like, you know, you have an eviction. So I did ask though. I said, well, if I had to move the stuff, could you come? There's mold present. 2 men in a truck said, no, they're not doing it. I can call, put Debbie on the speaker. This side up moving said, absolutely not. That's via text because of the mold present. A third party, he says, he has to see how bad it is, but with mold, he can't send his guides in there.
If I may, Your Honor, my client would be happy to give 30 days to get their stuff out, and after that, the writ would issue. There's some other options we can put on the table here to get this over and done.
I need to be able to find a place to stay. I can try. I don't know.
Okay, so here's the problem. You got to find a place.
Yeah, I've been trying it. Right?
No, you got to find a place.
I
Because if you can't find a place, so understand what will happen.
okay.
What will happen is I will set this for trial. If you lose that trial, it's not gonna, all of these questions aren't gonna matter because what will happen is I'll give them the authority just to put it out on the curb.
Your Honor, I need more time than 30 days to get out of there. It's not like I don't want to be there. I need to find. I don't want to go to trial. I really don't. I want to be done with it. But I need to find a place that rents. If there's something given to me.
Have you asked them how much time they'll get? They're saying 30 days. Have you proposed anything to them about time frame?
Yeah, I've told this to Mr. Eviction. I've told him that what's going on. I've been in conversation with him. He's just telling me, get out, get out, get out.
Okay, fine. But if he's saying 30 days, have you given him a time frame that you could do it?
He never said 30 days, but I cannot.
Okay, he just said 30 days. Do you have a time frame that you could do it?
I might need 90 days because there's an eviction. If the eviction can go away and I can get something from the court showing prospective landlords that I'm not on eviction, I'm not being evicted, I was never evicted, they will rent to me. My credit is fine. It's not the issue. It's just this fact. I didn't want to spend Thanksgiving in a hotel with my 4 kids or Christmas or their birthdays.
30 days, conditional order dismissal.
30 days is not enough.
With the reinstatement in the event that the,
Excuse me, Your Honor, can I speak, please, if you don't mind?
Sure.
Okay, Miss Janet Garden has been staying with us. The biggest problem out of this whole issue is the kids that are involved. And they came out of that house. My nephew was the ceiling fell, almost killed him. She just lost that. She lost one of our child during COVID. So it's been like an emotional roller coaster, a single mom with 4 kids. She's been paying our rent to this, the landlord. I've been helping out this family. And it's just to see when things happen and there's a crisis. Within those crisis time, everything everyone wants in the society is money, 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 money. Not forgetting the people that has been displaced in this situation.
Ma'am, that's not true here because they said, ma'am, that's not true here because they said that they just want the premises.
The guy's been very aggressive. Okay.
To think she's still trying to play the victim card after all this time is unbelievable. This issue has been dragging on for months, and if she were serious, she would have found a place by now. These excuses just don't add up.
What do you guys want to do?
I need more time. I will leave the premises.
Then what I'm gonna do is I'm gonna send you out there, talk to Mr. Evercheck. You guys try to figure out a time.
He's very aggressive,
Your
sir.
Honor,
He's very aggressive.
hold on.
All right, then you're gonna need to talk to me.
Yes.
If
Your
you
Honor.
want the bottom line of aggressiveness, you're gonna have to talk to me.
Yes.
So I'm gonna pass the matter. Have a seat.
Yes, sir.
Ma'am, what is your, there's no lease.
No.
So I guess the question becomes, why wouldn't I just give them a judgment and give you 10 days to move?
Well, because there was conversation of continuation of a lease prior to this collapse. And if it wasn't for the collapse, I probably would have at this point found a place to stay. And I would not be in a hotel spending thousands of dollars. And we wouldn't be here at all. And there would be no eviction. And I would have been able to get a new place smoothly and have my family safe and happy.
I mean, here's the reality of it. The reality is you're gonna need to move.
Yes.
All right. So from my standpoint, it's the issue of time. And you're saying you need 90 days.
At least, sir.
Well, that's not going to happen. I mean, I can tell you, I'm not going to issue a judgment for 90 days. Is rent being paid?
No, because the property is not habitable.
Got it.
There is rent in escrow from when this originally started as a non-payment, paid $2,500. So we would ask that be my client.
No. If it wasn't for the landlord's negligence, we wouldn't be here to begin with.
Okay, well, I can solve the escrow issue right now. I'm not returning it to anybody right at this moment. Okay. Because the issue is a move out. Well, let me answer it this way. I try to resolve these in a fashion where it is beneficial for both parties. All right. And let me ask you this. Would you be able to get this all arranged in 30 days?
No, sir.
All right.
I can, if you will allow me maybe 60 days. that would be more. If I can also get some from the court or the landlord stating that I'm not evicted. So when I do present my application to new housing, I can present that as well. Your Honor, how long does an eviction stay within your court, please? Because they do check that.
What do you mean, how long does it stay?
Like if a prospective landlord's realtor is looking at my name or pulling up records to see.
What, if they pull it up and they look at it, and what counsel's indicating is if we do this by way of a conditional order of dismissal, then it will look as though the case is dismissed.
Okay.
And then otherwise, it's gonna look like there's a judgment or a pending action.
Right. Okay. So the eviction is based on $200 that I did not pay for her to fix the plumbing because the plumbing was never fixed. Until the time that
Ma'am, if you want to litigate this case, then you can litigate it. And you're gonna be right at that 10-day period. But if you want to go ahead, you can go ahead.
Well, no, I don't want to be at a 10-day period. I would like to have time to get a company who's willing to move my stuff out with the mold situation.
All right, here's what I would suggest to the parties.
Okay.
That there be a conditional order of dismissal with that the defendant would vacate the premises by January 31st of 2025.
I apologize, Your Honor, I'm not doing the math, but is that more than 56 days?
It is not.
Okay, so we're under 56.
Yes,
I think that works out to pretty close to 45 days.
correct. So about,
My client's fine with that.
what about you?
Okay. T-shirt. Can I get something next week? I'm sorry, Your Honor. You said
The January 31st day, okay? Now, I think in the conditional order of dismissal, it would have to acknowledge that you're not residing in the premises, but that they're and won't reside in the premises.
sorry, I can't hear you.
That the conditional order of dismissal would have to indicate that you're not residing in the premises, will not reside in the premises, but that you have personal property in the or on the property,
Okay.
and that the personal property would have to be removed by defendant prior to that date.
Okay.
Okay,
Okay.
just so that we make that clear. All right. Also, in the conditional order of dismissal, the amount held in escrow, that the court will rule on that issue after the defendant has vacated the premises,
Okay.
as to where that property would go or where that money would go. And I can give a court date for you guys to come back. I need a court date in February. And that there's a hearing set on the escrow for February 4th, 2025 at 9 a.m.
Do we have to be here in person, Your Honor?
You'd have to submit a form to appear in Zoom.
I'm sorry, sir.
You'd have to submit a form if you're going to appear by Zoom. I'm not guaranteeing that I would say that you can.
Okay.
If you have if everything is out of the property, I'm going to be much more inclined to let that happen.
Sounds good to me.
Don't be surprised, but this woman is going to get evicted. She doesn't look like one willing to move out with her respect.
One more thing. In regards to the mold and everybody denying me to come in because of the mold, is it possible for you to put into the conditional that they can at least show something that the mold has been taken care of? So, because people are going to have to come in and pack my stuff, so they're comfortable doing.
Well, I'm not going to get into that. I will just say this.
Okay.
That mold can appear there's mold everywhere. The question is whether or not the mold is of a type and nature that exposure to that would jeopardize some impairment of human health.
It is.
I don't know that now.
No, I sent you the mold report.
I understand that, but there are differences there are still differences in that. So I am not going to I'm not here to make a ruling and will not make a ruling as it regards the mold and the like. If the folks that move in go in to move your property, have to mask up or do whatever it needs to protect themselves, and they certainly can do that.
Okay.
Because if you don't move the property, the reality is that's precisely what plaintiff is going to have to do in regard to getting the property out of the premises. So, all right. Anything else?
That's pretty much what I got for you guys on this one. Hopefully you enjoyed the video. If you did, make sure to leave a like and possibly subscribe to the channel. Thanks for watching, and I'll see you on the next one.